We welcome you to this audio series intended to provide information to those eligible for Air Force legal assistance, which include active duty military members, their dependents, and retirees. Our hope with this series, which we are calling The Art of Law at Hill Air Force Base, is that we can convey legal assistance information to you that is readily available, provide information that is responsive to your needs, and to do so in a timely manner. This series is for information purposes only and is not intended as a substitute for legal advice from an attorney. Welcome to this podcast discussing landlord-tenant related issues to lease agreements for our military members. We are welcoming Michael Bassett from the Legal Assistance Office as a guest speaker and lecturer into this podcast series to raise awareness of tenant challenges from the last few years. This is a hot topic that gets frequent attention in the legal office. So, Michael, what are the most frequently asked questions relating to tenant challenges here at Hill Air Force Base?
Thank you for inviting me. I appreciate that. I'm going to go ahead and highlight those issues involving tenant concerns. A lot of tenants have come into the office asking for assistance, and we see these questions frequently, so this will give us an opportunity to enable our members to have all the necessary tools in the tool bag to effectively communicate and receive the benefit of the bargain of their lease.
So when you say the benefit of the bargain, what do you mean by that?
Well, the lease agreement is a binding contract for a leasehold between landlord and tenant who have agreed on the terms and conditions of their lease, which requires an element of fairness agreed to by the parties. Those terms and conditions are subject to a set of assumptions such as covenants of good faith and fair dealing and other covenants. So this isn't your great-grandparents' lease where the landlord made all the rules, nor the lease of feudal times in medieval England. In modern eras, such as now, the residential leases are essentially social constructs monitored by the state of Utah and the federal government, which are enforced with laws, and protections have been placed onto those leases to protect against overreaching by landlords. So both the state and federal government will police those lease agreements and apply a standard of laws and a standard of care to the agreement. Both landlord and tenant should be able to receive the benefit of that agreement according to the terms and conditions.
So what do you mean by the standard of law?
Well, the state of Utah has incorporated into its statutes warranties which the landlords must extend to tenants, such as the warranty of habitability, certain licensing requirements, zoning codes, and health department standards, which are a few that come to mind. Likewise, the federal government has imposed anti-discrimination laws under the Fair Housing Act requiring that landlords are subject to the act and must not discriminate. Additionally, the rental unit must be fit for occupancy, the unit having an occupancy permit from the health department. If that permit is revoked, the unit is no longer habitable and may not be occupied. On top of all that, the landlord must have the required licensing in place and conduct the repairs and maintenance according to law.
What is meant by standard of care as it relates to these landlord-tenant relationships, and what determines if the unit is habitable?
Great question. Generally speaking, the unit must be sanitary and maintained in good condition to be considered a habitable and safe dwelling place, free of safety concerns, and must be up to code with the proper smoke detectors, plumbing, heating, and air conditioning. It cannot have, for example, loose flooring damage, water damage to the floors, must have working plumbing, and comply with emergency egress requirements or fire escape. So it's really a question of fact. The state of Utah has applied a warranty of habitability to all rental units and codified that known as the Fit Premises Act, which can be found in the Utah Code, Title 5722.
Who is responsible for making sure the unit is habitable?
It's a great question. Initially, it's the landlord and their agents, such as the property management company, that must certify that the unit qualifies and is ready to rent and obtain the proper licensing clearances. Sometimes requires a state inspection from inspectors to maintain certifications with fire code and local ordinances, such as inspecting for the absence of mold. So some of those duties can then transfer to the tenant under the contract, under the lease, for the tenant to fix and maintain aspects of the tenancy, while other duties remain with the landlord. For example, the tenant must maintain the premises, change the batteries and smoke detectors, comply with smoking regulations, and perform cleaning. But the landlord must make sure the plumbing systems, heating and air, and electrical are working, and appliances as well.
What if my rental unit has an infestation of some kind? Because we often get those kinds of questions.
That's a big concern. Infestations can happen, such as rodents, mice, or cockroaches. So if an infestation is in the unit, typically the tenant is responsible for conducting the remediation and is required to hire fumigators or obtain pest control necessary to maintain control of those infestations. But it also depends on the condition of the property. At the time the lease was entered into, any kind of pre-existing condition is usually the responsibility of the landlord, whereas a new or ongoing problem during the tenancy is most likely a tenant responsibility.
That's great information, Michael. But what if my landlord isn't doing the repairs? How do I require that repairs are made?
The state has a set of remedies under the Fit Premises Act. Utah Code 57226 has a list of renters' remedies for deficient conditions of the rental unit. The landlord must provide safe and livable housing. So if you have a faulty toilet, no hot water, broken staircase, peeling flooring, exposed wires, those are just some examples of what landlords are required to fix. So one of the assumptions of the Fit Premises Act is that the remedies only apply if the renter is current on its obligations. So rent must be current. In addition to rent, the premises must be maintained and must be used in accordance with zoning laws. Additionally, the first step to getting repairs done is to notify your landlord in writing if the repair is needed. I prefer that tenants submit something in writing, such as an email, to document that request instead of just a phone call or a text. Sometimes those are acceptable, but sometimes the landlord will delay, and then we don't have a record of when the tenant first made contact, because the landlord is required to make repairs from the time they're notified to initiate repairs within 3 calendar days. If the landlord refuses or fails to make those repairs, the tenant can file a form and serve that called Notice of Deficient Conditions upon the landlord. The landlord must then begin repairs within the 3-day period. If the landlord fails, the tenant then has 2 options. There's a rent abatement remedy or a repair and deduct remedy. So rent abatement allows the tenant to deduct up to 2 months of future rent, or alternatively, the tenant may also move out.
So if the landlord fails or refuses to conduct repairs in a timely manner, how can I enforce that? Or how can the tenant enforce that?
Great question. The tenant has to serve a notice upon the landlord under Utah Code 5717-3, serving a 3-day notice to make the repairs. And if the owner fails to comply, or the property management company acting for the owner, the renter may then serve a notice upon the landlord to formally make those repairs, or if not, if they fail to do so, those remedies will kick in: repair and deduct, or move out. And that could be very damaging to the landlord. So I know that as a landlord myself, those tenants have to be, tenant units have to be maintained pretty quickly. And so I don't know anyone that waits beyond the 3 days. So serving the landlord a notification is a necessary requirement.
So how do I protect my property in the event of a disaster?
Yeah, great question on disasters. That's a common question. We if you've lived at all, you know that floods and fires and accidents are just a way of life. So to protect your property, keep in mind the landlord's insurance only protects the landlord's property. The tenant or renter should, but is not always required to obtain a policy of renter's insurance. Your lease might require that. I can't tell you how important that is. For only a few dollars per month extra, it covers your entire household of goods, clothing, electronics, or anything that might get damaged in a catastrophe, and even dog bites. So dog bites can be a very high risk factor, sort of like driving without car insurance. If your animal bites a neighbor or a guest, you're liable. And the only way to make sure you're protected is to have insurance. So it's protecting your property. Insurance is protecting perhaps your entire livelihood, which could be at stake.
So, Michael, one of the big questions we get in the legal assistance office is about security deposits. When is a tenant allowed to get 100% of their security deposit back, and when might they not receive a full deposit?
Here's how that works. When your lease ends, the landlord must refund a security deposit to you within 30 days after the close of your tenancy. If the landlord fails to return the deposit, the tenant is automatically entitled to 100% of the security deposit to be refunded, plus a penalty of $100. The tenant is required to serve notice of the security deposit demand to the landlord and give the landlord 5 days to pay it. So some problems occur when you don't know your new address. You can give an alternative address, but often you don't know where you're moving to or don't have an address yet. So that address is a pretty important factor in providing that to your landlord. So in addition to the deposit refund, landlord must provide an itemized balance of any charges, prepaid rents, and a written notice of those deductions being withheld from the deposit. So as you can see under the security deposit statute, Title 5717(3) is both a substantive requirement and a timeliness requirement, requiring landlords to return that deposit within 30 days. There are deductions from the security deposit, such as non-refundable items that must be agreed to in advance in writing. Those can be deducted from the security deposit. There should have been a check-in, move-in checklist, and move-out checklist as to the condition of the property for the tenant to establish what repairs are needed, what damages have occurred, and what might be wear and tear. If the landlord failed to return your deposit within 30 days, it doesn't much matter what damage or wear and tear items, as the landlord simply failed and is required to now return the entire amount. So I would encourage all tenants also to take a short video and photographs of your unit as you move in and move out to document any damage.
I know one of the questions we often get as it relates to deposits and refunds is clients will come in and say, well, I'm being charged for wear and tear. Will you explain for the audience what is wear and tear, and how much can somebody be charged against the deposit?
Sure. Wear and tear are items that are really foreseeable and understandable that both parties take into consideration at the time of the lease. So wear and tear is not allowed to be charged against the tenant's deposit. Usually the wear and tear items are forecasted into the landlord's rental pricing, so these items cannot be charged. Some examples of wear and tear might be holes in the walls, nails from mounting pictures, photographs, or cracks in the door or drywall from vibrations, or maybe a wood floor needs new varnish, maybe the carpet is fading and getting a little bit thin. So these are all foreseeable items considered wear and tear. Landlord cannot charge for them. Anything that's considered excessive wear and tear falls outside the realm of wear and tear and is damages. So the landlord may collect for that, whereas normal wear and tear focuses on issues that are predictable and anticipated, so long they didn't arise out of negligence, carelessness, or accidental abuse towards the property. So for those items, those are outside of wear and tear, and the landlord may charge for those and deduct those against the security deposit.
Well, thank you for that information. I know that will be very helpful to a lot of our clients who come in concerned about wear and tear. Since we are on the topic of security deposits and rents, would you please tell me how the SCRA, or the Servicemen's Civil Relief Act, applies for military members and their ability to terminate a lease?
Service Member Civil Relief Act of 50 U.S.C. 535 is a pretty important law to make sure that you and your family as a military member are allowed to break your lease early. So it's one of the benefits and protections of the SCRA. Now that could happen due to your deployment or permanent change of station, PCS. In those circumstances, the member will need to provide a copy of the military orders or PCS to the landlord and seek protection under the SCRA to terminate the lease early. Most landlords are pretty familiar with the SCRA protections and will allow the renter to break their lease by providing a copy of their orders to the landlord. In those circumstances, the lease will end 30 days after the date when their next payment is due. So for example, if today is May 31st, the next rental payment is June 1st, for example. The lease will end 30 days after that, so the month of July will be the last month under the tenancy, and the lease will be terminated under the SCRA.
So how can I end my lease early if I'm not covered by the SCRA?
If you're not covered by SCRA, then I assume you are not a military member, you're a civilian, but you can still end your lease early. You just won't have the protections of SCRA. So this is typically done by negotiations. You'll need to ask your landlord to meet with them and work out an arrangement to perhaps pay a penalty and maybe an extra month or two of the rental value. That should bring your lease to a close, hopefully. The landlord might also ask you as the renter to pay for advertising or marketing, or perhaps agree to assume the risk of the vacant months until the unit is released.
So a couple of questions here. First, going back to the SCRA, you say it applies to service members, but do their dependents also get to enjoy the protections of the SCRA?
Yes, the dependents and family members get the protections of SCRA, so that extends to families who are maybe living apart, living at different sides of the country, need to relocate. So those protections are included to the family members and dependents.
So that's great information on the SCRA, Michael. As I understand it as well, if a spouse who's not a military member is having to move with the military member, they're also covered under the SCRA. Is that correct?
That's correct. Under Section 3959, the spouse and children within the household moving with the member are protected and are allowed to break the lease in the same manner as the military member. There might be a difference if it's an independent child or college student living apart. That is not impacted, not materially impacted under the statute. They don't receive the protections of SCRA.
But just to be clear, an individual, a tenant who's not covered, technically can be liable for the remaining lease period up until the time that the landlord is able to re-rent the premises. Is that correct?
That is correct. So the negotiation, resolving your lease by negotiation, is the goal, and sometimes that does not happen. So the worst case scenario, you could be liable for the remaining months under your lease. The hope is that you can limit those, maybe put a stop of maybe 2 months on there. If that doesn't work out, some landlords will want you to be liable for the entire remaining period of the lease, and that is a risk factor. So it's good we point that out, that there is a potential risk of the entire half year or months, whatever might be left on your lease. So it's our advice to get you to your landlord's office or property management office and try to work that out by negotiation.
Michael, question I have, though, are there any other exceptions in the SCRA that would allow a tenant to get out of their lease? Say, for example, they are PCSing, permanent change of station, or deploying.
Sure, that's a great point of clarification. So under the SCRA, you must have at least 90 days or more away from your current duty station to qualify for the protection. So if you're only going for a week or two to a TDY, I don't think that would qualify you to terminate your lease. Additionally, if you are separating from active duty as another protection under the SCRA, you may terminate your lease. I think you would just need to bring papers to your landlord showing the pending separation orders, and that renders the protections of the SCRA in place.
So another important topic that comes up in the landlord-tenant arena is the Fair Housing Act. Can you explain for the audience, what is the Fair Housing Act, and is my landlord required to follow it?
For sure. The Fair Housing Act is a federal and state law requiring that landlords follow rules that avoid discrimination. Most landlords are required to follow it, but some are exempt. Under Utah Code 5721.3, the exemptions are listed. Here's how that works. So if a landlord has 4 or more units, they are required to follow the Fair Housing Act. Under 4 units, so 3 or less, they would not be required to follow that. Once a landlord is subject to the Fair Housing Act, The landlord may not express a preference, limitation, or discriminate on the basis of race, color, religion, sex, national origin, familial status, source of income, disability, sexual orientation, or gender identity. So the penalties for any violation are pretty severe under Title 57, 2111. A violation of the Fair Housing Act could be up to $10,000 fine. An aggrieved party can pursue a claim under a 63G, which is Administrative Rulemaking Act, and ask for an investigation within 180 days. The Labor Division, Anti-Discrimination Division will investigate and adjudicate any violations of law.
Well, thank you, Michael, for bringing to this audience your knowledge and insight in this very important topic of landlord-tenant law. So for those out there who still have questions, you may be wondering, how can I receive more advice to a very specific question? We're happy to provide that advice to you in your situation, in your particular set of circumstances. Please feel free to reach out to us at the Legal Assistance Office at area code 801-777-6626, and you will be assigned one of our attorneys to give you more advice on the matter. Again, thank you for listening.